All right. Hello. Um, I'm Marisa Nelson of the Law Office of Marisa Nelson. I'm a California attorney, so everything I say is California specific, but a lot of it does apply in a lot of places. So just be sure to check out your local rules if you're not in California. I'm here today with Tara. We're going to discuss a few questions. You want to go ahead and introduce yourself? Tell us anything you want to share, and we'll go from there.
Oh, okay. Yeah. So I'm Tara, and I was very excited when Marisa posted about this because I have experienced quite a few losses recently and want to get my own estate in order. And so to have the ability to ask some questions has been very exciting.
Awesome. Yeah. I'm very glad to have you here. And I know we talked about one thing just now that we wanted to discuss. Should we start there? Or do you want to start in with your questions and we'll just see where the
Uh,
conversation takes us?
let's hop in with that question about guardianship.
Yeah. So you were asking about kind of guardianship and what kinds of restrictions you can place on guardians as far as specifically raising your kids within their religion or forcing them to go to church, that kind of thing. Is that a good recap?
Yes, that's a great recap.
Perfect. Okay. So I guess just to back up half a step, um, naming a guardian is a super important part of estate planning. It's one of the biggest reasons people finally get around to creating a will and or trust and the related documents, one of which is to nominate a guardian. And we all hope that parents will be here to raise their kids well into adulthood, but just in case, super important to name who you would choose if you're not there to do that yourself. So it's one of those things that can be really easy to put off because of questions like the one we're about to discuss. Like, what if they raise my kids in a different religion or different values or different schools or different location? Like, there's a lot of pieces that can come into that. And I will say, as difficult as it might be to choose someone to raise your kids, it is always going to be worse not to have your own say in that situation. So by nominating someone while you're alive and well to do so, that's how you get to have your say and who would do that very important job if needed. So to an extent, yes, you can create restrictions, provide guidance for the people you're choosing. I think it's important to keep in mind that anyone acting as guardian is going to be human. So even if we had absolute legal authority to ban them from, indoctrinating our kids into their religion, if it's not something that we agree with, even if they're the most well-meaning people in the world and they have no intention of putting their religious beliefs onto your child, people are people, and it comes up as part of our daily lives. So I think that's just something to keep in mind when deciding, like, would this actually work given their beliefs, whether or not they align with mine and what I want to share with my children. So there's some amount of restrictions and guidance that we can place that way, but our own beliefs are always going to come into how we live our lives, and that's seen by children, even if it's not actively taught, right? And then within that, there's kind of two pieces. There's what can we legally require, and along with that, like, what is actually enforceable? Like, would a judge know that that's happening? Will they be able to do anything about it? How will they do anything about it? And then there's the personal, like, presumably when we're naming someone to be guardian of our kids, it's someone that we know and like and trust to be in that very important role, and hopefully they would want to do whatever we ask them to do within reason. So there's also that element, like, just will they do what we ask even if it's not legally binding and legally enforceable. So to kind of separate those, like, the legally binding stuff should go in a legal document that says I I nominate this person, I direct them to do such and such. Here's how I want that to look legally. And then you might also want to have a separate letter that just expresses your hopes and wishes and dreams for your kids. And that might be written to the kids, it might be written to the guardians, maybe one for each of them. And I think in a lot of cases that can go a long way towards sharing our wishes, for one thing, because a lot of times people say, oh, well, they'll know, but a lot of that stuff people don't inherently know. And even if they did, it can be a super good reminder in the moment to have this written record of what's really important to you to share with the guardian and with your kids. So in a lot of cases, even if it's not legally binding, that can go a long ways towards having people know and do what you would like in those situations. As far as whether or not whether you can direct someone regarding religion and attending church with your kids and that sort of thing, I don't actually know offhand if you could make that a legal requirement. The general gist when we assign someone as guardian or nominate them, and then the court confirms that if it actually needs to go forward, is they're given kind of the legal rights of a parent to, care for your kid, take them to the doctor, make sure they go to school, pay their bills, that kind of thing. So I don't know if you could require or force one way or the other there, but I think that's really, realistically speaking, regardless of the legal realities, I think it's going to come down to choosing a guardian who is not so different in their religious beliefs from you, that if their religious beliefs rub off on your kids, are they so different that that's going to be a really big problem for you? And if so, then maybe they're not the right guardian. And if that's beyond that, I think that letter that says, here's kind of my hopes and wishes and dreams for how you would raise my kids and for you as my kid, I think is going to go a long ways towards that. Yeah. So
that makes sense, and that was kind of my thought and my concern was there's not you can't be oh well, this person took my kid to church and now there's somebody reporting it to the courts, right? It seems really ridiculous, but there's still that concern of hey, it's different. And then while you were talking, one thing that came up for me was how often do we see say grandparents, right? You don't have grandparents set up as guardian, but grandparents are wait, I want to step in. Can they try to override your will and be hey, I'm kin, I want access to my grandbabies, and you're well, this person over here is who I nominate, for that reason, if their values are different or they're toxic or whatever reason, you don't name a grandparent. Can they fight that in court?
I would say that's actually a super important reason to make your wishes clear and to nominate someone in writing. Because if you don't have anyone nominated in California, and I believe in most states, if you have nothing in writing about what you would want to have happen, who you would want to be the guardian, the court is going to do their best, but they're going to be bound by this default state law list of who has priority to be guardian, and it's based on blood relationship. So closest living blood relative who is an adult and isn't a convicted felon, that's who the court is going to have to go with if they're willing and able. So a grandparent would likely be relatively high on that list, but if you've nominated someone else and made clear that this other person is who I want, then in general the judge is going to confirm what you've chosen over that default list of blood relationships, so long as the person that you've chosen hasn't been arrested for a felony since you nominated them, that kind of thing. It's there's not a ton of requirements for who can be in that role, but there's going to be some amount of court supervision and checking that is this person willing and able? Is this a safe environment to have the kids go live there? And so long as that all checks out, then the court is going to go with what you've nominated. So you're 11. Well, you write down this list of who your choices would be. It's best to have backups in case your first choice is not available. You can place caveats on that and say, like, well, this person, unless this has happened or not happened. So like these people, unless they're no longer married to each other, and then, you know, if they're not, then I prefer these people, or these people, so long as they're still living in the Bay Area or Washington State or the US or whatever your preference is there. Yeah. So that kind of.
Yeah, that makes sense. And then also with that is, so if you have like an older sibling that's like, say 19, and then you have like younger siblings who are like, say 8 or something like that, would the sibling be able to have precedence over grandparents, or would that typically, just because they're so young, override it?
That is a good question. I don't know where siblings lie on that list. I would expect they're fairly high priority, but it might vary by state whether they have priority over the grandparents or not. I definitely think that's an important area to make your wishes known one way or the other, and also consider too if that is, it's going to really vary by individual whether someone is at all able to take that on at 19. And in some cases, that's going to be the best call. In some cases, it won't. But definitely important to make your wishes known in a legally binding writing so that the court knows what you would want.
Okay. How often should people be reviewing their wills and their guardianships?
I would say, I mean, there's different levels of review. Like the initial thing is like, are these still the right people? Are they still who I would choose today if I made this document a year ago, 5 years ago, whatever? So that's generally quick and easy to do. And I would do that probably once a year, or if you think about it more often, sometimes something happens and immediately it's like, oh no, we got to change this. Like, because we know that's who's in charge. I would say at least once a year, and then probably have an attorney review things a little less often, like every 3 to 5 years. If you're not aware of any reasons that something needs to be changed, it's still a good idea to have a lawyer check it. But the biggest thing is definitely, are these still the people I would choose today?
That makes sense. Yeah. So with the trusts, it typically, like, you hear or see in like fiction or whatever, they talk about like the age of majority being like 21 or 25. Is that like a typical thing, or is it legal adulthood? Like, how does that work, or is it stipulated by the adult, like the parent?
So it does vary a bit by state, and also like what right or responsibility we're talking about here. Like there's a lot of things in inheritance law, at least in California, that once you hit 18, you have all the rights and responsibilities of an adult. Or there's a few things where it may be a little bit older, but in general, like if you don't have an estate plan in place and you leave assets to your kids, as soon as they're 18, they're going to have full access. So that may vary a little bit state by state, but that's generally the case. Whether or not an 18-year-old is capable of doing any of the things that come up in estate law, whether it's inheriting and managing their inheritance wisely, or acting as trustee and managing your assets for other people wisely, I think that's a separate consideration that's very individual by individual. But most things, other than renting a car, they're going to have the legal rights and responsibilities as soon as they hit 18 in a lot of states.
Okay, that makes sense. So is it feasible to have somebody else be your executor if you have, like, you know, an 18 or 19-year-old child? Or does that, like, say both me and my husband were to like die in a car crash, would we be able to list somebody other than our oldest daughter, or would it automatically fall to her as the oldest and being 18?
You can absolutely list someone else if that's what makes sense for you. And I frequently encourage clients to list whether it's another family member, like if you have an adult sibling that you trust, or a parent or grandparent, or a friend. There are also professional fiduciaries who will act as the executor and trustee, who, you know, can be a great option. This is their day job. They know how to do it. They're not trying to get it done on evenings and weekends after work. So those can all be great options. And you can say, like, you know, this person, and then if my kids are over this age, they can be in charge. Or you know, depending on how close we are to that milestone, it might make sense to not say that quite yet. Just say, like, these are the people who are going to be in charge. These people are, you know, my siblings, my parents, whatever, professional. And then once your kids are old enough that, like, you they're either there or almost to the point where you know that they have not only the age but the financial skills and responsibility and all of that, and then you can, that's one of the most common reasons to update things is, you know, we made this when my kids were small, now they're 30, they're responsible, I know their financial habits and skills, let's update things to make them the trustees and executors. Yeah, so they definitely don't have to be the ones in charge of things. You can have this is who will inherit my assets, and these people over here are who will do all the work and manage things. So they can be the same people or a different list of people.
Oh, okay. And is it common to have more than, like, can you have co-executors, or is that like a one person show?
You absolutely can, and I do see it done with mixed levels of success.
Okay.
Sometimes it can be great to have a partner to work through the decisions and the paperwork together. And sometimes, especially with siblings, I find it can be harder than just having one person involved. Both because of the sibling dynamics types of things that can go on, and also because a lot of it is not going to be a divide and conquer type of situation. It's going to be like all of us have to sign, all of us have to deal with the bank, we all have to show up together. Like Wells Fargo, I've found, really wants all the trustees to show up in the same place in the same time, which is not always convenient if they're in different geographic locations or somebody has mobility challenges. So while it can reduce the workload, it doesn't always. Sometimes it just duplicates it. So I tend to advocate for having one trustee or executor at a time, and then listing others as backups. But there are cases where it can work well. So it's really a case by case, and looking at, like, how well do these people work together in a really tough situation? Because if they're becoming trustees, there's probably been a death of someone close to them. People don't always behave in their normal way. grief does very funny things to our brains. And then you add to that like a whole new overwhelming job, figuring out what the assets are, what am I supposed to be doing here, what is my job in this role. Like, I can't just do whatever I want with these assets. Like, the job of trustee and executor is a fiduciary role that's regulated by a lot of rules of what needs to be done, and people can disagree over that, as well as some of the discretionary things like, do we sell the home or rent it out? So I tend to find it's easier to have one person at a time calling the shots, and then hopefully they also discuss and share with the other people involved. But that's certainly not always the case. I have had clients that were co-trustees together and did a good job. So
how often do you find that there is complications? So say like spouses are legally separated, they're not divorced. and then the one spouse dies and they list their child as opposed to like their separated spouse. Do you see that happen like with complications often?
Um, I wouldn't say often, but it has come up enough recently that it is definitely a thing. um, and even whether you're married, separated, divorced, single, you do have a right to say like who will be your trustee and executor and power of attorney and all that stuff, and who inherits your assets. It does vary by state how much of that defaults to your spouse and how much of that you can say actually not my spouse, if you're still legally married or some level of somewhere in between married and divorced. It definitely can cause complications, and it's a little bit extra tricky because there tends to be so my work as a wills and trust lawyer is under the probate code, and then divorce law, custody, that kind of stuff is under the family code, at least in California. And there are a lot of areas where there's overlap and coordination and like parallels, and then there's definitely some areas that like, well, in the case of a death, then this rule applies, and if they're getting divorced, it's this rule, and it comes into like separate property and community property, and whose debts are these and whose assets are these, and that's also going to vary by state for sure. So it ends up being this like weird mix of like, okay, I totally understand how my work and the family law side of things play together in this section, and then there's other sections where it's like you really need to talk to a family law attorney to get the details there. And that's always a fun place to be, in between two different experts saying, well, you need to ask them about this, and I can advise you on this part but not that part. So it's certainly not clean when we have those kinds of in-between situations. So there can be good reasons, of course, to not go immediately from married to divorced, but if you find yourself hanging out in any kind of gray zones there for a long period of time, it's, from a legal standpoint, it's worth resolving if you can, so that you can have more control and awareness over how that situation of somewhere in between married and divorce is going to affect things like who inherits your assets, who's in charge in an emergency, and so that you can have full control over what that looks like. Because if you're not sure if you want to be married to someone anymore, then that probably is going to impact whether you want them inheriting your assets and whether you want them in charge of your kids' inheritance and things like that. So it can definitely get real messy.
Yeah, it sounds like it. I was just bringing that up because when my mom died, my dad had to sign for her cremation, and I was not expecting that because they'd been separated like 25 years. But because they were still technically legally married, he had to sign the forms, and so I had to like call him and be like, "Hey, come in." And so it's made me really think about like you really have to think of some of these really in-depth things that people don't necessarily think about when they are, in our 30s, right? With how that impacts kids and wills and trusts and all of that stuff. So it's definitely an interesting like situation. And I would say it sounds like it could get incredibly complex for you to try to have to like sort it out as well.
Yeah, and I think it's very true. And I think what's worse in that situation is like yes, it can be challenging to sort through things, but it also really sucks giving bad news to a client that's like, this is the rule on this, and there's nothing I can do about it. When they're already grieving, dealing with a tough situation, and now it's like you're telling me that my ex, or whoever's involved here that's living and talking to me, I never want to have to tell someone that yeah, this person that's not really part of your life anymore, they have legal rights. And that is a good tie-in. Also, like another area where some similar issues can come up is unmarried couples who choose not to get married, often for many years, and that's an increasingly common choice, and there's lots of reasons for that. And there's a big legal impact to that. If you're a couple who is not married, in most states you will have zero rights to be involved whatsoever if your partner passes, and possibly even if they're ill and hospitalized. So whether it's same-sex couple, straight couple, any combination thereof, if you're one of the upsides to marriage is that there's some legal rights involved there, and that's not to say that everyone should get married or that the legal rights should dictate what you choose to do in that situation, but just as people who are formally spouses but never fully legally went their separate ways, people who are still in a relationship but didn't choose to get married, the wills and trusts and inheritance laws and rights to visit and all of that kind of thing don't acknowledge those relationships in most cases. So extra important to do some estate planning if that's what someone is choosing for their relationship. So that can also be a pretty heartbreaking situation to find yourself in.
So with that, I'm thinking about all the changes that have happened even in the last 10 years. That really would impact things like you said, like same-sex relationships, or even like non-traditional family relationships. I mean, I see right now they're talking about like queer platonic relationships, or friends that live together and own a house, or polyamorous relationships. All of that stuff, I would assume, if it's not like really written out in an estate plan, that can really be quite impactful, I would imagine.
Absolutely, yeah. And even in a state like California, where domestic partners under the law are treated as married legally, if a couple is still in a domestic partnership and chose not to then get married once they were legally able to do that, the federal government does not recognize domestic partnerships, even though they do finally recognize marriages to, it's not quite equality yet, but much more than they used to. A lot of people don't know that that being domestic partners in California, even if you're registered and you have employer benefits and all of that stuff, if the federal government does not call you married, then you still don't have all the same rights, even if California treats you as such. So that's another area that's super important to be informed about what the rules are now. And I'm concerned that things, as much as they've been moving towards increased inequality over the last 10 plus years, I'm concerned that it's going to be getting worse again in the near future for as far as equality goes. And even more important than it's ever been, to make sure that your estate plan reflects whoever it is that you want in your life in these important roles: inheriting, being your trustee, being your trusted trustee, executor, healthcare agents. Like, get it in writing, whatever the rules are now or in the future about marriage and rights to each other. That's going to be increasingly important, I think, to document that stuff, as it does with all these things we're talking about. Really, like, whatever the law says, it's important to document what you want to have happen in each of these situations. And that's really what my job comes down
to. Speaking of equality, we know that typically a person who is on disability benefits can't have more than like $2,000 in assets. So if they had a parent or a domestic partner that died and they inherited, can that negatively impact your assets in that regard?
Absolutely, yeah. Super important. It's another area that's super important to have some planning, is if you have any desire to leave your assets to someone that is on any kind of needs-based benefits, whether it's a result of a disability, needs-based like Medicare or Medi-Cal, there's all the different variety of benefits, and they each have slightly different requirements, but a lot of them require basically no assets. And if you inherit even a small amount, it can get you kicked off of those, including medical benefits that that are tied to that. There are solutions, often a special needs trust or other similar ways of handling things. You can leave an inheritance to someone for their benefit without just handing over cash, without saying, here you go. You can say, this is for you, but someone over here is going to manage it to ensure that we don't get you kicked off of your benefits. So special needs trust is a big option there. And it can make a huge difference for people in preserving life-saving medical benefits while also having them able to benefit from this inheritance. And it's super important to handle that before something happens, because once someone passes and leaves the assets to you, options can be extremely limited about whether there's anything we can do about it at that point. So yeah, if there's any chance you'll be leaving assets to someone that is on needs-based public benefits, definitely do some planning so that you're not harming them more than you're helping.
That makes sense. And so when you're like building out trusts or whatever, if you have like a disabled child, you can actually set up that trust so that somebody can manage to make sure that they're getting like medical care. Is that correct?
Yeah, absolutely. And an important piece of that is you can set up that planning now without locking in any assets or preventing you from using those assets right now. There's sometimes a misconception with trust that like if I set up any kind of trust right now, I have to like put those assets in there and then like not touch them, or I'm locking myself into something. There are types of trust where that's the case, but for everything that we're talking about here, including special needs trust, there is plenty of ability to set up the structure now without actually committing any assets to it. So you're like set up the trust, and then you have this basket here that's waiting to help this person out. And then only when you pass, then the assets are in this trust. And at that point, it's not changeable, but you would set it up, have it ready to go. You're not, preventing yourself from using those assets. In the meantime, you can say, when I pass, my house will go to my disabled kid in this trust, and this other person will make the investment decisions, make sure that the assets are used in a way that best benefits my kid.
Okay. For like, say you have like a 529 for your child, and you die before they're college age. Does it just sit there and they're able to like access it when they become college age, or like how does it go away? Like how does that typically work?
So 529s do vary a little bit by the financial institution where you've set them up, and different states have different rules. But generally, the money would still stay there. Like, so you would set it up, and you're the owner, or there's sometimes different terms for it, but you create the account, you own the account, but the beneficiary is the child that you've listed on the 529. They would still be able to use those assets when they're at the age that it's set up for them to use them for education. You can generally on the account name an alternate. So if one kid doesn't use the funds, then what happens to the funds? And also, if you're no longer there to manage the account, then who would manage the account? So there are two separate roles there. So always a good idea to check like whatever financial company you have the 529 with, see what you're able to do on their form to plan for that. Like, if I'm not here, what happens? If my kid doesn't use the funds, what happens to them?
Cool. Okay, thank you.
Yeah, great questions.
I think that's all of my questions.
Okay, awesome. Yeah, we covered some really important stuff. So thank you for bringing those today.
Yeah, thank you for answering it and making it seem less intimidating.
Yeah, that's such a important goal of mine. I think one of the biggest barriers to getting this stuff taken care of is that intimidation factor, that overwhelm, that like I don't really know how to do any of this. How does it work? I need a lawyer. Lawyers can be kind of intimidating, and it's just,
Yeah.
add to that the emotional element of all of these things, and it can really prevent these important steps from being taken. And so, that's kind of my approach, is to make it bite-sized, more approachable, less overwhelming. So, obviously, for anyone in California, I'm happy to help do that. And hopefully this also, even if you're not in California, gives you kind of a starting point for having it be not only more approachable, but like finding an attorney that fits your style as well, and that you feel comfortable talking to and can walk you through it. Yeah. So,
Yeah.
and if you do move forward with that and have questions, or there's anything I can do to help you getting started, even with another attorney, just let me know. It's super important to get this stuff done, and I'm on a mission to make that easier. So
Yeah, and I appreciate it because I feel like it's really kind of taboo, and it shouldn't be, because we all need to be thinking ahead. Otherwise, it
mhm.
becomes, a problem if something happens. So,
Yeah, it is like there's so many pieces of it that we kind of don't talk about or don't want to talk about. Like there's of course the death element, but also like the finances element, that like, oh, we don't, we don't need other people in the family to know our financial situation or things like that. And then you deal with attorneys, and yeah, there's so many pieces of it that can feel not like we don't talk about that. We don't talk
yeah.
about Bruno, right? Yeah. So awesome. I hope this really that makes it easier to move forward with that. And I always tell people, like, once you start looking into this stuff and are feeling that, like, okay, this is actually kind of easy, I can do this, like, ride that momentum with whatever the next step is that you need to do to figure this out, whether it's looking for a lawyer, or doing some research, or finding out about some piece of this, like whatever is the next step, like try to keep that momentum, because it can be so easy to put off and go back to, like, oh, I'll deal with that someday. And hopefully you'll have plenty of time and get it done before you need it, but we just don't know when that'll be.
Yeah. Well, thank you so much. I really appreciate you, sharing your time and expertise, because it
Yeah,
definitely helps kind of put my mind at ease. So.
perfect. Well, thanks for being here. Let me